This is English shorthand dictation number 186 and the dictation speed is 160 words per minute. Ready? Start. There is a lesson from the ongoing failure of the monsoon session of Parliament until there is a clear link between how one performs in Parliament and the votes one gets in elections. Politicians will not change the way they approach their role as legislators. The House has not run smoothly so far, and given the impasse, an immediate resolution does not appear to be on the horizon. There is a possibility that the session will not see Parliament perform its main role of deliberative lawmaking, holding the executive accountable and articulating citizen-centric issues. The immediate trigger for the impasse is the opposition's demand for a discussion and inquiry on Pegasus and the government's reluctance to do so. It would be productive to have a discussion on Pegasus and then pursue other legislative business. There could well be other mechanisms to resolve the impasse too, but the question is why the government and the opposition have not invested enough energy in resolving what is really not an intractable issue, and that goes to the question of incentives. For a government that enjoys a majority and can get its legislative agenda through even amidst a din, the functioning of the House does not make a material difference to its objectives. Non-functioning allows it to evade hard questions. For the opposition, the ability to disrupt, make a noise, even snatch papers from ministers seems more politically advantageous. They think this allows them to come across as belligerent and aggressive. For members of Parliament who would like the House to function, there is little room to generate pressure because their incentive lies in proving their loyalty to the party line. But at the core of it, members of Parliament know that what they do in Parliament will not affect their electoral prospects. Attendance, questions asked, interventions in key debates hardly figure in the heat and dust of electoral battles. Therefore, till parliamentary performance becomes a parameter in how citizens judge their representatives, India's parliament will continue to see bursts of productivity interspersed with bouts of disruption. Honorable Speaker, Sir, I strongly oppose the introduction of the bill as it is a draconian legislation to cut down the democratic and legitimate rights of the workmen in the country. Sir, the provision in the bill is to prohibit the strike. The Essential Defence Services Bill is violating the fundamental right guaranteed in Article 19 of the Constitution of India. The sole intention of the bill is to curtail the democratic rights of the defence civilian workers. Sir, the legitimate right of workers to strike is guaranteed in the Industrial Disputes Act 1947 and also in the latest Industrial Relations Code. The infringement of the legal right of the employees is a violation of all these rights as well as the provisions of the ILO conventions. The ILO conventions have already stated that the right to strike is the democratic right of the working class in the country. It is being unilaterally curtailed. The entire purpose of this legislation is to cut down the democratic right of the working class in India. Hence, I strongly oppose this bill, and I also appeal to the Honorable Speaker that this is not the way by which a bill is introduced when the House is not in order. This is a very important bill. There are 41 ordnance factories in India. Now the government of India under the Ministry of Defence is trying to convert them into separate boards. It is an indirect way of privatization of ordnance factories in our country, and the sole purpose of this bill is to ban strikes. Sir, 84,000 employees in the defence sector, particularly in the ordnance factories, will be affected by this. Banning the right to strike means taking away the legitimate right of the workers. There is the Industrial Disputes Act of 1947. Even the labor courts are there. Unilaterally taking away the right of the workers is an undemocratic step. I want to move the amendments, but passing a bill in the pandemonium is not proper. It is not fair as far as the parliamentary practice is concerned. The Essential Defence Services Bill 2021 seeks to replace the ordinance promulgated in June 2021. The bill allows the central government to prohibit strikes, lockouts and layoffs in units engaged in essential defence services. Essential defence services include any service in any establishment or undertaking dealing with production of goods or equipment required for defense-related purposes, or any establishment of the armed forces or connected with them or defense. In addition, the government may declare any service as an essential defense service if its cessation would affect the production of defense equipment or goods, operation or maintenance of industrial establishments or units engaged in such production, or repair or maintenance of products connected with defense. The bill amends the Industrial Disputes Act 1947 to include essential defense services under public utility services. Under the Act, in case of public utility services, a 6-week notice must be given before persons employed in such services go on strike in breach of contract, or employers carrying on such services do lockouts. Under the bill, strike is defined as cessation of work by a body of persons acting together. It includes mass casual leave, coordinated refusal of any number of persons to continue to work or accept employment, refusal to work overtime where such work is necessary for maintenance of essential defense services, and any other conduct which results in or is likely to result in disruption of work in essential defense services. Under the bill, the central government may prohibit strikes, lockouts, and layoffs in units engaged in essential defense services. That government may issue such order if necessary in the interest of sovereignty and integrity of India, security of any state, public order, public decency, or morality. The prohibition order will remain in force for 6 months and may be extended by another 6 months. Strikes and lockouts that are declared after the issue of the prohibition order or had commenced before the issue of prohibition order will be illegal. The prohibition will not apply to layoffs made due to power shortage or natural calamity, or layoffs of temporary or casual workmen. Employers violating the prohibition order through illegal lockouts or layoffs will be punished with up to 1 year imprisonment or rupees 10,000 fine, or both. Persons commencing or participating in illegal strikes will be punished with up to 1 year imprisonment or rupees 10,000 fine, or both. Persons instigating, inciting, or taking actions to continue illegal strikes or knowingly supplying money for such purposes will be punished with up to 2 years imprisonment or rupees 15,000 fine, or both. Further, such an employee will be liable to disciplinary action, including dismissal as per the terms and conditions of his service. In such cases, the concerned authority is allowed to dismiss or remove the employee without any inquiry, if it is not reasonably practicable to hold such inquiry. All offences punishable under the bill will be cognizable and non-bailable. The General Insurance Business Nationalization Amendment Bill 2021 seeks to amend the General Insurance Business Nationalization Act 1972. The Act was enacted to nationalize all private companies undertaking general insurance business in India. The bill seeks to provide for a greater private sector participation in the public sector insurance companies regulated under the Act. The old Act set up the General Insurance Corporation of India. The business of the companies nationalized under the Act were restructured in 4 subsidiary companies of General Insurance Corporation of India, namely National Insurance, New India Assurance, Oriental Insurance, and United India Insurance. The Act was subsequently amended in 2002 to transfer the control of these 4 subsidiary companies from General Insurance Corporation of India to the central government, thereby making them independent companies. Since the year 2000, General Insurance Corporation of India exclusively undertakes reinsurance business. The Act requires that shareholding of the central government in the above 5 companies must be at least 51%. The bill removes this provision. The Act defines general insurance business as fire, marine, or miscellaneous insurance business. It excludes capital redemption and annuity certain business from the definition. Capital redemption insurance involves payment of a sum of money on a specific date by the insurer after the beneficiary pays premiums periodically. Under annuity certain insurance, the insurer pays the beneficiary over a period of time. The bill removes this definition and instead refers to the definition provided by the Insurance Act 1938. Under the Insurance Act, capital redemption and annuity certain are included within general insurance business. The bill provides that the Act will not apply to the specified insurers from the date on which the central government relinquishes control of the insurer. Control means the power to appoint a majority of directors of a specified insurer or to have power over its management or policy decisions. The Act empowers the central government to notify the terms and conditions of service of employees of the specified insurers. The bill provides that schemes formulated by the central government in this regard will be deemed to have been adopted by the insurer. The board of directors of the insurer may change these schemes or frame new policies. Further, powers of the central government under such schemes framed under the Act will be transferred to the board of directors of the insurer. The bill specifies that a director of a specified insurer who is not a whole-time director will be held liable only for certain acts.